Thank you, Chairman Tonko. I think it would surprise a lot of people to learn that our landmark law on safe drinking water is designed to set standards based on cost benefit analysis instead of health protection. Because the structure of the statute requires EPA to set a maximum contaminant level goal based on health risks, but a goal is not a standard. And instead, the statute directs EPA to set standards that are weaker than the goal based on cost benefit analysis. So I wanted to ask Ms. Wu. Right now, the statute double counts in my opinion, cost considerations. First, it limits standards of what is feasible, a term that by definition means that there's some amount of cost taken into consideration. But then the statute layers on top of feasibility this cost benefit analysis, which further weakens protections based on price calculation. So, I guess my question, Ms. Wu, do you think that our drinking water standards should be set based on health risks? I mean, should we get rid of this cost benefit analysis? Should we still keep the feasible standard? What is your opinion so that we get to this health risk goal and not put so much emphasis on cost consideration?
Yes, I agree. The feasibility part of the standard does require that costs be taken into consideration already. So really the cost benefit analysis, like you said, is an extra added layer. And there's so many problems with how you do cost benefit analysis, especially the fact that you can often undercount the benefits. So the benefits with it often are outweighed by the cost when you do that analysis. So then it just gives EPA that much more reason to further weaken the standard. So really just focusing on feasibility, which already accounts for costs, is enough.
Okay, then let me go to another question I wanted to ask. Maybe I'll ask everybody this one. There's an important concern under the Safe Drinking Water Act, in my opinion, with regard to the protection of vulnerable populations, which includes infants, children, pregnant women, and the elderly. So can I ask the witnesses, maybe just yes or no? Let me just ask yes or no. If the witnesses agree that infants, children, pregnant women, and other vulnerable populations should be able to safely drink their tap water. Ms. Wu, yes or no?
Yes, absolutely.
Ms. Vanderdy? Vanderai?
Yes, sir.
And finally, Ms. Chard, yes or no?
Yes.
Okay, then let me go back to Mr. Wu, Ms. Wu, along the same lines, but if you could elaborate. In your view, does the Safe Drinking Water Act currently protect vulnerable populations? And if not, what more needs to be done, in your opinion?
Right now, I don't think it does. And what needs to happen is beyond just saying that the EPA should consider vulnerable populations when it's looking at doing the standards, they should be more explicit that EPA actually needs to set regulations that actually protect vulnerable populations. I think that explicit level needs to be added to it because EPA hasn't been doing a good job about accounting for and then protecting those populations.
And then I know 4 years ago, this committee came together and agreed that chemical substances are not safe if they aren't safe for vulnerable populations. And so I'm hoping that we can all agree that the same be true for our drinking water, because we can't really say that our drinking water is safe unless it's safe for all. Ms. Yu, are you familiar with what we did with the chemical substances with regard to vulnerable populations? Are you familiar with what we did with that?
Unfortunately, I'm not as familiar with the TSCA as I am with the Safe Drinking Water Act.
All right. Well, I know Mr. Shimkus and Mr. Tonko are familiar with TSCA, and I would say that we should try to use the same example, but that's for another day. Thank you very much. Thank you, Chairman Tonko.